Oh, small update. Acerthorn was issued an order to show cause why he shouldn't be sanctioned $1,500 in the Commander Imperialsalt case in the Central District of California. Actually, that's a really interesting one, too. You want to hijack the stream for a second here, and we'll go over to Court Listener. Just search for David Stebbins and see what happens. David Stebbins, David Stebbins, David Stebbins, David Stebbins. This is 84 pages of David Stebbins. Okay, yeah, I'm going to need the case number. I have to, yeah. There's too many to look up. Okay, let's go descending now. Motion to appoint counsel for order to show cause by David Stebbins. Okay, let's see. Where is order to show cause? Minutes in chambers. July 2022, Stebbins of Arkansas filed a copyright infringement case that we're familiar with. Commander Imperialsalt and Zelzander, and later identified Jared Jones. This was the accidental live stream, I think, that he posted, and then allegedly the defendant posted it on Kiwi Farms, or was it he privatized his Patreon and then charged people for seeing his videos, and then I think they posted them on Kiwi Farms for mockery, okay, but posting the whole thing for mockery is not exactly the same thing as a fair use. So the judge entered minutes reflecting a July 2024 meeting that the parties had settled. For purposes of adjudicating the motion, the settlement was defendant will make $100 payments over 18 months, $1,800. Defendant shall pay $100 by the 5th of each month. Each party shall bear their own costs and fees. Right, and now there is a debate over the PayPal fees. Defendant has committed an anticipatory breach of the settlement agreement by not agreeing to pay slightly more than $100 to cover PayPal fees. Plaintiff alleges that defendant requested plaintiff's payment information so he could make the first payment. Oh, I remember reading this. Defendant offered to pay via direct bank transfer, but Stebbins was hesitant to share his bank information, so they agreed to do PayPal. Defendant would pay plaintiff every month $100 via PayPal. Then to cover the fees, defendant needs to send $104.12. Defendant sent $105 on September 5th and October 9th, but then made a $100 payment in November via friends and family. But plaintiff claims that he's going to get hit with fees of $398, not $412. Then defendant paid an additional $5. November 9th, plaintiff asked if he would comply with the settlement moving forward. There is something in contract law called reassurances, reasonable reassurances of performance. So you can ask your contract party, your opposing contracting party, are you really going to make the delivery on time? And if they can't say, yes, we're going to make the delivery on time, then you're allowed to suspend your performance to some degree, sometimes entirely. So November 9th, they did the reassurances. Defendant responded that he would not pay more to cover the fees, would not mail a check to plaintiff, would not agree to liquidated damages as a condition of obtaining bank information for a direct transfer. Plaintiff asks the court to ensure defendant pays the $100 per month and that defendant be responsible for any fees. Defendant claims that plaintiff is misrepresenting the fees. He sent it via friends and family, so PayPal should not be charging any fees. Defendant claims that plaintiff's own exhibits show he received $105 in payments with no fees deducted. Defendant argues that plaintiff has violated the rules by failing to meet and confer before filing the motion. So this is plaintiff filing against defendant, it looks like, at the stage of the history that we're looking at now. Plaintiff argues that because defendant did not file a separate motion, the court should deny defendant's request for a refund. Plaintiff submitted a supplemental brief. He states that he has learned that some courts facilitate payments between parties. He'd be willing to use this method. Plaintiff filed a second supplemental brief in support. He claims that defendant's most recent payment was made via PayPal's friends and family, and that plaintiff does not consent to being paid via that method because a friends and family payment is a personal gift and does not count towards the settlement. What? He requests that the court declare the December payment has not been made, and the defendant still owes him $100. So he's trying to claim that the friends and family payment was a gift. What the heck? The friends and family payment is a gift. No, you use friends and family when you're paying your friends and family for something. You go out to dinner and you split the bill. You send a friends and family payment for your portion of the bill, and PayPal doesn't deduct fees. That's what that's about. But then PayPal also doesn't give you certain types of buyer and seller protection if you do the friends and family payment, if I understand correctly. Anyway, he tries to get the court to agree that a friends and family payment is a gift. The judge correctly goes straight to principles of contract law, as you do, and contracts start with sort of the normal interpretation of the words of the contract. And if there is something to be filled in, if there's a gap to be filled in, usually the state's contract law has a normal way of filling in that gap, otherwise known as gap filling provisions. They use California law, preponderance of the evidence, plaintiff bears the burden of proof. An anticipatory breach occurs on the part of one of the parties when it positively repudiates the contract by acts or statements indicating it will not or cannot substantially perform essential terms of the contract. The anticipatory breach may be either express or implied. Local Rule 7.3 provides that the parties must meet and confer at least 7 days before filing a motion. In no event may the parties stipulate to conduct their meet and confer efforts exclusively via emails, letters, voicemails, with no same-time interaction. They want same-time interaction. They want real-time, person-to-person interaction. The parties are expected to extend professional courtesies, etc. Plaintiff's motion says the motion is made following the conference of counsel pursuant to Local Rule 7.3, which took place November 9th through 13th. The exhibit contains an email exchange that concludes with a message from the plaintiff. Even if you reply to this message, I will not respond. I will entertain no response from you except unequivocally affirming that you will comply fully with the settlement. Plaintiff filed the motion 7 days later. Defendant contends that plaintiff did not satisfy the local rule because he did not engage in any phone call or meeting to discuss the matter, and he would not respond further to the defendant's concerns. Plaintiff contends he's already conferred, so ending the communications with an ultimatum does not show bad faith. This is amazing. This is like watching a mud fight. Two people fighting in the mud. Sure, I'll watch. It's not. I don't know how it's benefiting anyone whatsoever. You guys are fighting over $1,800 or actually $5. And yes, it seems like one person is the aggressor now, but the other person was messing with them. PayPal defines a commercial transaction as a transaction in which users accepted the user agreement to buy or sell services or make any other type of commercial transaction. The domestic commercial transaction is a transaction occurring when both the sender and receiver are registered with PayPal as residents of the same market, so long as the individual makes or receives payments from a PayPal balance or attached bank account, no fees are deducted. Plaintiff has not proven anticipatory breach. Defendant told plaintiff that he would continue to send $100 per month using the Friends and Family program, which does not deduct a fee. Plaintiff's response is telling. Plaintiff claims he did not knowingly misrepresent that plaintiff charged him a fee. He faults defendant for not researching the truth of plaintiff's claims before agreeing to pay a few extra dollars. Next, plaintiff claims the defendant is not allowed to use PayPal's Friends and Family program because the settlement is a commercial transaction. He accuses defendant of defrauding PayPal by using the Friends and Family option. Plaintiff admits that he demanded defendant pay extra for fees that PayPal never charged by failing to prove that fees were deducted and essentially admitting that they were not. Plaintiff has failed to prove anticipatory breach. Plaintiff's motion for sanctions is denied. Plaintiff says, I refuse to accept PayPal's personal transaction option due to it being fraudulent. Even if I'm wrong, even if the personal option isn't fraudulent, it doesn't matter because I have the absolute and non-reviewable, which means no court review, right to refuse any payment method except legal tender and the court can't stop me even if it wanted to. The court has a quote. If I really, really, really wanted to be an a-hole about this, I could in theory demand nothing less than defendant driving all the way out here himself from California to Arkansas, walking up to my door and personally handing me $100 in cold cash every single month, or at least hiring a local courier to do the same. I would be squarely within my legal right to require that, says Stebbins. Plaintiff is mistaken, says the court. A settlement agreement is a contract, and the legal principles which apply to contract generally apply to settlement contracts. All contracts are governed by the covenant of good faith and fair dealing. The duty imposed by the covenant is one of good faith and fair dealing in the performance and enforcement of the contract, spitefully insisting on personal delivery of cash payment when no such term is part of the settlement agreement would clearly violate the implied covenant of good faith and fair dealing. Rather, basic contract law provides the manner of payment may be determined by reference to custom and reason when the contract is silent on the question. Gap filling provision. So you've got a gap here. They didn't say how the payment would be made, so now we go to the custom and reason when the contract is silent. Here, defendant made his first 3 monthly payments using PayPal's Friends and Family program. I'm not sure if he did or didn't. The parties agree that this mode of payment is convenient and secure. Plaintiff received those payments and was not charged a fee. Okay. The court finds that defendant's use of PayPal's Friends and Family program is reasonable and consistent with custom and reason. The settlement agreement is not an agreement for the purchase of the sale of goods, nor are the parties residents of the same market. The court hereby authorizes defendant to continue to use that method of payment and declares that defendant has not breached the settlement agreement by doing so. For these reasons, the December payment that defendant sent in this manner counts towards satisfying defendant's obligations under the settlement agreement. The parties agree that the defendant paid $105 for September, $105 for October, $105 for November, and $100 for December. This adds to an overpayment of $15. Defendant may deduct $15 from his next monthly payment and send $85. Order to show cause. By signing a paper filed with the court, a party represents that to the best of that person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, the factual contentions have evidentiary support. On its own, the court may order a party to show cause why sanctions should not be imposed for a violation of Rule 11. Rule 11 is intended to prevent frivolous filings and filings made for an improper purpose, such as personal or economic harassment. In his motion to enforce the settlement agreement, plaintiff wrote that defendant needed to pay him more than $100 per month, so that plaintiff would still have $100 after the PayPal fees were taken out. He told defendant exactly how much he would need to send to ensure I receive $100. He contends that when defendant offered to pay him $100, defendant did so knowing he would leave plaintiff with less than the agreed upon amount. He claimed defendant should pay $104.12 every month because PayPal takes $4.12 for itself. He represented, I never receive $104.12, not even for a split second. In fact, prior to plaintiff filing this motion on November 11th, PayPal had not deducted any fees from the payments defendant sent because defendant made all the previous monthly payments using his PayPal balance or bank account, along with the Friends and Family tab. As the recipient of multiple payments, plaintiff must have seen that PayPal did not deduct any fees, yet he falsely claimed that PayPal had deducted fees. When defendant confronted plaintiff with this misrepresentation, plaintiff said, defendant has not proven any misrepresentation was done knowingly, and when it comes to defrauding someone, knowing misrepresentation is required. That is not the standard for Rule 11 sanctions. Accordingly, by December 30th, tomorrow, plaintiff shall show cause in writing why he should not be sanctioned $1,500 for filing a motion with the court based on false claims that PayPal had deducted fees from defendants' monthly settlement payments. And that's the end of that. So yeah, that's interesting. Mr. Stebbins may have overplayed his hand a little bit and got the court's attention. And the court, when you're being a jerk to the court, or when the court notices you're being a jerk to opposing parties or whatever, the judge is a person. They will start to look for things. If you are being a jerk to everyone and you're not letting them have a little bit of leeway on scheduling and little mistakes here and there because everybody makes little mistakes, some people more than others. And Mr. Stebbins has no room in his life for someone to make a mistake in any way, let alone a way that affects Mr. Stebbins. And by so strictly trying to hold the defendant liable for even a perceived mistake, in this case, the PayPal fees were not being deducted. It was a perceived mistake. He has overplayed his hand and exposed himself to, in this case, a sanctions order to show cause. The judge rightly is holding Stebbins to the same standard Stebbins is trying to hold the defendant to, but Stebbins is not correctly holding the defendant to that standard. It is not proper for a party to try to invoke the power of the court incorrectly, arrogantly, impolitely, even. I've noticed something about this world. You probably noticed it a long time ago, but the truth and the merits are a rung below politeness and etiquette. You could be injured in the legal sense, and you could be a meritorious party coming to the court with a good argument. But if you do so impolitely, the court will do everything it can to prevent you from proceeding. On one hand, that's fine, but if mathematics was impolite, it would still be true or false. If science was impolite, it would still be true or false. If nature was impolite, it would still be true or false. Your argument to the court, maybe you shouldn't be impolite. Maybe there should be a sanction for being impolite, but you shouldn't lose your argument because you were impolite. But that does happen. You do find that in the world, and it bleeds into the court system as well, because that's part of the world and made up of people. That people judges and people clerks and staff do not look dryly at what's going on and take abuse and take impolite parties without looking for opportunities to correct or punish those impolite parties. Whether or not they should or not, we can discuss this. This is a philosophical discussion. This is a philosophical YouTube channel about the philosophy of law and what's right and what's wrong, and why. Because to me, that's my religion. That's my Sunday morning at 10 a.m. is asking philosophical questions about how our human society and government work.